was an entity called CCW Systems, Inc. It was a company that operated a CarX auto repair business here in Knoxville. It purchased some auto parts from a Chattanooga-based auto parts supplier called Ken Smith Auto Parts. That's the plaintiff in the case. In connection with those purchases of auto parts, the president of CCW Systems, Inc., Michael Thomas, signed a one-page document that was basically a form that had Ken Smith Auto Parts letterhead at the top of it that was called an open account application. And that's the primary document that's at issue in this case. CCW Systems, Inc. ultimately went out of business. It wasn't able to pay Ken Smith Auto Parts for the parts that it purchased. That's the debt that's at issue here. But Ken Smith Auto Parts never sued CCW Systems, Inc., the principal obligor. They only went after Mr. Thomas, the president, claiming that he was personally liable for the debt. So the primary issue in this case is whether Mr. Thomas is personally liable for the debt that was owed by the corporation CCW Systems, Inc. The trial court actually granted partial summary judgment on the issue of personal liability. So that was decided before the case reached trial. The trial court had said as a matter of law that Mr. Thomas was personally liable based on the language in the open account application. But really, in the trial court summary judgment order, the only finding that the trial court made was basically that the open account application contained personal guarantee language. And the court said that that language was clear and unambiguous because it said, I hereby personally guarantee all invoices due Ken Smith Auto Parts, Inc. There's no further elaboration on that by the trial court. And our position is that the trial court incorrectly applied the test to determine whether a corporate officer representative is personally liable for a debt. That's the test in the 84 Lumber versus Smith case from the Tennessee Supreme Court, which basically says that if a person signs a contract only one time and only in a representative capacity, the contract as a whole has to show that the party's clear intent was that the representative be bound personally. And so the trial court didn't engage in that analysis here. Just to kind of go through the facts of this case with the open account application, there's no dispute to start out with that the only entity that actually entered into the open account application, the contract, was the corporation, CCW Systems. It's listed as the applicant on the open account application. So there's no assertion that Mr. Thomas purchased any goods himself. The only argument is that this single sentence in the open account application, I hereby personally guarantee all invoices due Ken Smith Auto Parts, Inc., made Mr. Thomas personally liable.
Let me ask you a question.
Sure.
Now, according to my notes, this sentence is above the signature where Mr. Thomas signed. Is that correct?
It is immediately above the signature. The problem here,
I personally guarantee all invoices due Ken Smith Auto Parts, Inc.
That's correct, Your Honor.
Okay. What does that mean then?
Well, the problem is that the test isn't whether the language of the contract states that the representative personally guarantees the invoices. That brings me to the Creekside Partners case that we cited. That case, the contract, it was a commercial lease in that case, and it also included the same kind of clear and unambiguous language that stated that the representative personally guaranteed the debt of the entity. But the Court of Appeals in that case found that nevertheless, that didn't meet the test in 84 Lumber, that the clear intent of the parties looking at the contract as a whole demonstrated that there was a clear intent that the representative be personally bound. This case is very similar to the Creekside Partners case because in Creekside Partners, the personal guarantee language was not set off in any kind of way or emphasized.
How big, excuse me, how big was the contract in that case?
In that case, it was a much longer contract. It was a commercial lease, but the important point that the Court of Appeals made in that case was that the personal guarantee language was buried among other unrelated provisions.
And is it your position that this language is buried in this one contract that's really one paragraph? It has the form to be filled out, right?
Yes.
And then it's a one paragraph, a short one paragraph.
Absolutely, and there's a variety of
Is it your
unrelated.
position that the language is buried in there?
Yes, absolutely. It's a paragraph of completely unrelated provisions. You've got payment terms in there. You've got an attorney's fee clause. You've got the return check fee. It's all just run together. It's in tiny font at the bottom of the agreement, and and it's a single sentence that says, "I hereby personally guarantee all invoices due." Mr. Thomas submitted a declaration in opposition to summary judgment stating that he didn't ever see that because it was buried in among the other boilerplate provisions. And so,
Well, you keep saying amongst the other boilerplate provisions. I mean, it's a short one paragraph. And did your client say he didn't see it, or what was his exact language? What was your client's exact language?
in his declaration,
Yeah.
he said that he never saw it and he never intended to personally guarantee any of the debt.
I'm trying to find, again, my notes. What he said, though, about how quickly he looked at the contract or what?
Yeah, I don't recall the specific language, but he basically said that he glanced at it. He didn't notice the personal guarantee language. He thought that it was all in order, and he signed one time as president of CCW Systems, Inc., which the law says creates a presumption that he only signed in his representative capacity. That's what he says he intended to do, and while that language is right above the signature, it is in tiny, almost unreadable font. It's merged together with those other provisions. It's not separated from the other language in any way, and those are the kind of things that the opinion in Creekside Partners determined were facts that suggest that there was no clear intent that the representative be personally bound. So those are facts here that make this case more similar to Creekside Partners and less similar to the 84 Lumber case, where the personal guarantee language was in all caps, it was bold, and it was set aside from the rest of the text of the document. You don't have any of that here.
I found the part I was looking for. Your client, I think, in his declaration, said, "I glanced at the form quickly." Maybe you should have said, "I read the form."
Well, if it had been set aside like the language in 84 Lumber, in that contract, he would have seen it, I think. But nevertheless, he didn't notice the personal guarantee language, and that's, he signed in his representative capacity only. That's another point, is that the only case relied upon by the trial court was the MLG Enterprises case, which that case involved two signatures. So it is completely irrelevant to the facts of this case, because if Mr. Thomas had signed a second time, there'd be much stronger evidence that he intended to be personally bound. The fact that he signed only one time in a representative capacity shows that he didn't intend to be bound. So
Is it stated in the contract that it's a representative capacity?
Well, the way that he signed it indicates that. The text immediately before his signature says authorized signature, which suggests that he's signing on behalf of an entity, and then immediately after his signature is the typed word title, and he wrote in president and then dated it. So those are all facts that show that he signed in a representative capacity rather than individually. And again, the only applicant under the open account application was CCW Systems, Inc. That's at the top of the application.
Do you agree that, what is this? CCW Systems, Inc., that it was unnecessary for it to personally guarantee the debt?
Yes, I'd agree with that. Mr. Thomas signed in his representative capacity.
I understand.
That was how CCW Systems,
But
Inc. became
you
bound.
agree, though, that there would be no need for the company to hereby personally guarantee all invoices due Ken Smith Auto Parts too, because it was already liable under the
Yes,
contract?
I'd agree with that.
Okay.
But that isn't the end of the inquiry as to whether that language
I understand.
ultimately evidences the clear intent of the parties. Another issue in this case is the fact that the debt was time barred. Just briefly, there was no dispute that the debt was time barred. The trial court found that the statute of limitations was extended based on an express promise to pay. Our position is that the testimony at trial was not sufficient to establish an unconditional promise to pay. The allegation was that Mr. Thomas had called the law firm representing the plaintiff and stated, basically, I have a real estate deal that's going to close and I'll take care of the balance. The implication was from those proceeds after that deal closes. There's nothing in the record to show that he ever followed up on that or stated that the deal had ever closed. At best, it was a conditional promise, which doesn't meet the test, that there has to be an express acknowledgement of the debt and an unconditional promise to pay in order for the statute of limitations to be extended. Two other problems with the trial court's judgment in this case. Neither CCW Systems, Inc. nor Mr. Thomas ever agreed to pay 18% interest. The trial court awarded 18% interest based on what was on the invoices. There was one sentence in the open account application that said that CCW Systems, Inc. basically agreed to any terms that were on an invoice, but those terms didn't exist yet, so there was no meeting of the minds as to that. And also the attorney fee award in this case is improper because the trial court never considered the Rule 1.5 factors that are an absolute prerequisite to an attorney fee award. Thank you.
Thank you. You have your time for rebuttal. We'll hear from the appellee.
If I may reserve 2 minutes.
You don't get to reserve any.
Oh,
You have 15 minutes. You don't get to reserve any.
yes, sir. Justin Lane, here from the Chattanooga Bar, here for the appellee, Ken Smith Auto Parts. If it pleases the court, the first issue which I'd like to address is the personal guarantee issue. Our position is that the trial court was correct in finding a valid personal guarantee and ruling in our favor on that issue at summary judgment. As comments have been made already today, the contracted issue is one page. Basically, it's one paragraph, and the signature occurs directly below that paragraph. And the language, I hereby personally guarantee all invoices due Ken Smith Auto Parts, is clear and unambiguous. I would point out that the signature of Mr. Smith, of Mr. Thomas, actually almost touches the word personally as it occurs directly above. We would liken the case to the 84th Lumber case in which there was a personal guarantee. I think that case was also an open account application, and if I'm not mistaken, I think it was also one page. But in that case, there was the person to be charged signed, but there was only one signature placed. The Supreme Court held that when he signs, he can sign in his personal capacity and representative capacity. As that court held, it said it's a bedrock principle of contract law that one who signs the contract is presumed to have read and be bound by its contents. Language in this case was clear. It was directly above his signature. The trial court cited the MLG case. In that case, there was two signature lines, but the main issue in that case was where the person to be charged out beside the signature field where he was to personally obligate himself, he wrote that he was signing it for the company, And naturally, after the fact, when he's actually to be charged, he argues there that, well, I signed only in my representative capacity. The Supreme Court, citing to 84th Lumber, said that this was not effective in contradicting the clear intent of the contract that the signatory be personally bound. The relied upon by the appellant is the Con Oil case. The Con Oil case indicated that it's a legal nullity to have a corporation that's signing to personally guarantee its own obligation. That opinion, I would argue, actually supports our position. The other case that's been cited is the Creekside Partners case. In the Creekside Partners case, I think that the lease was 18 pages long, 20, if I'm not mistaken, 2,600 lines of text. There was some ambiguity in the terms on that contract, in that the person to be charged, at one point he was referred to as a tenant, at another point he was referred to as a guarantor. At one point in the contract, it referred to the guarantor and it said the guarantor's information will occur on a separate page, but on that separate page, it was actually left blank. Also in the Creekside case, the signature was separated from the binding on the individual language by, I think it was 2 separate pages. So that case, we would argue, is a different set of facts altogether. In our case, again, the sentence read, "I hereby personally guarantee all invoices due Ken Smith Auto Parts." It was directly above. His signature almost touches the word personally. The intent of the party, whether or not he glanced at it or why he signed it, he's presumed to have read the contract and be bound by its contents, and we would argue that there's nothing more clear than "I hereby personally guarantee all invoices due Ken Smith Auto Parts." The next issue I'd like to address is the acknowledgement of debt doctrine. There's no question in this case that we would be time barred but for the acknowledgement of the debt. The acknowledgement doctrine has origins that date back to English common law. I've tried to provide a thorough survey of the states, jurisdictions that have incorporated the acknowledgement doctrine. All those states, there's subtle differences. Some states require or do not require that the condition be, or that the acknowledgement be unconditional. Some states require it to be in writing. The one commonality in all the states and jurisdictions that have incorporated the doctrine is that it resets the statute of limitations. And that is a reset whether the acknowledgement occurs before the statute is run or after. I've cited, to try to illustrate that point, when the federal government was setting the statute of limitation on government claims, it sought to actually, Congress sought to put itself on the same footing as litigants. So in 28 U.S.C. 2415, which is the statute of limitations on government claims, it sets it out in subsection A, contract claims, subsection B, that statute tort claims. In A, for contract claims, it provides that a partial payment or acknowledgement of the debt is deemed to reset the accrual date on the statute of limitations. And that, I would contend, is evident in Graves versus Sawyer, which indicated that acknowledgement of the debt and promise to pay operates to keep the debt alive for the statutory period, and it used the words "from that time." The court in Ingram versus Earthman attempted to explain this distinction. It indicated that it explained the acknowledgement doctrine in terms of if the acknowledgments before the statutes ran, it's equitable estoppel that's the true mechanism. If it's after the statute is ran, it just basically reiterates the garden variety acknowledgement doctrine. That is that it would renew the obligation. But this distinction elsewhere is not, as far as my survey of the law, this is pretty isolated to Tennessee, as evident in that 28 U.S.C. 2415. We've also cited the Dern versus Olson case, which is actually an Idaho case, but I feel that it is instructive. It indicates that the actual function of the acknowledgement doctrine is a waiver of the time period which is passed up until the time of the acknowledgement. And that case, it actually indicated when the debtor makes a promise before the action is barred, he does not make himself liable a second time for the same debt, and the old promise is not merged into the new. He merely continues his original liability for a longer term. In other words, he merely waives so much of the period of limitations which is run in his favor. But when the action is barred, a new promise creates a new obligation, and it is itself the basis for the action. The Griffin versus Lear case also supports that analysis. It notes a new promise made before the debt is barred by the statute of limitations is held not to create a new and substantive contract, but merely to evidence an existing liability and to fix a new date which the statute runs. Acknowledging a promise made before the statute run vitalizes the old debt for another statutory period dating from that time. So we would contend that the Ingram versus Earthman case just didn't give the complete analysis. I'd cite for the court the footnote 19 of that case illustrates their wrestling with the issues, particularly on how to evaluate the consideration before and after the statute is run. But that is our position on that. And moving along in terms of, as I have stated, Tennessee has incorporated the doctrine, but it is amongst the jurisdictions that require it to be unconditional. I can tell the court what is not a valid acknowledgement. That is the phrase, which was apparently a common phrase a long time ago, a good man's debt never dies, or a good man's note never runs out. The court has indicated that this would be a statement of general language, and both of those cases indicated that.
Counsel, what do you say to opposing counsel's argument that it was at best a conditional promise to pay? I've got this real estate I'm going to sell, and I'll pay it out of the proceeds.
Yes, sure. The analysis on conditionality, you look to, because what's required is an acknowledgement of the debt and an express willingness to pay. So you would look at the intention of the party. I've cited several cases, the Dern case, also there's the Takaman case, which indicates when the condition is not inconsistent with an intention to pay, or where the acknowledgement itself, it's not conditional. So he never said, if this real estate deal doesn't close, I'm not going to pay you. You look to his intention.
Well, did he say, according to, I don't recall who it was, but it was an employee of your client, did he say that I'll pay it out of I've got this real estate I want to sell, and I'll pay it out of the proceeds?
The notes indicate July 12, 2013, defendant stated he was closing a real estate deal soon and would take care of the debt then. Call him back in 2 weeks. We called him back in 2 weeks, and he stated that he had not closed yet and that we should touch base again soon. He felt like he was going to close soon. It wasn't until like a year later where he flat out said, the business is closed down, I don't have any money, I'm not going to pay you. But you look to the intention of the party and whether or not the condition is, amounts to a refusal if that condition is not met. I would cite to the court conditions precedent are disfavored in this state. Typically, a pay when paid provision is not, it's not usually construed as a condition precedent, but is just a term affecting the timing of payments. We've cited the Luna versus Edmonston case. That was the Tennessee Supreme Court case in which the conditionality aspect of an acknowledgement was actually a jury instruction. Moving on, while I have time here, as to the late fee, the 18%, the appellant has argued that it amounts to an agreement to agree, which I would argue is a mischaracterization of a continuing personal guarantee, especially when you have an open account which envisions multiple transactions that are going to take place over a period of time in the future. If they did not agree with the terms on the back of the invoices, they could have sent the items back. If he did not agree that he continue to be personally obligated, he could revoke the authority, the personal guarantee. As to the attorney fee.
Well, let's go back on that a little bit more. How many different invoices were sent that made up the $6,000 some odd dollars?
That is in the proof, but it was a lot.
Several invoices?
It was over the course of like a year. It went all the way up until October of 2012, I think. The attorney fee, though, the court indicated that it was on a contingency fee, and that was the reasonable fee in Chattanooga. As for that, also, when it's a contingency fee, the law is that justifies a higher fee. The defendant cited in this case, or the plaintiff, that he's not paid a dime, and that is the truth. We have taken this case up to the Supreme Court. It's went back down. I've been in sessions. I've been in multiple times in circuit court, and we put on a lengthy trial in this case, and it's still on a contingency fee. So
your time's expired. Thank you.
Thank you, Your Honor.
We'll hear from the appellant rebuttal.
Just briefly, Your Honors, the Cone Oil case that was cited by both parties in their briefs, the idea in that case that to personally guarantee an entity's own debt is a legal nullity, that's true, but it's not the end of the inquiry. And the Creekside Partners case shows that's there's still a presumption. The Cone Oil case says there's a presumption when an officer signs a contract only one time and only in a representative capacity that representative is not personally bound. The Creekside Partners case, counsel said that language was unclear as to what was actually being guaranteed, but it's not. It's clear and unambiguous. The language in that case said the undersigned Albert Nathan Scott does hereby guarantee and become primarily liable as a co-tenant and does hereby promise and agree to pay unto the landlord, its successors and assigns, such sum or sums of money as will be sufficient to make up such deficiency and fully satisfy the conditions of this lease. That was a clear, if you're just interpreting the language, it was a clear personal guarantee by Albert Nathan Scott, the representative of the entity's debt. But that wasn't the end of the inquiry. The ultimate outcome in that case was that he was not personally liable, because there has to be more. There has to be a showing that the contract as a whole demonstrates that the clear intent of the parties was for the representative to be bound. Here, the trial court just said, well, it says that he personally guaranteed it. That means what it says, and that's the end of the inquiry. The trial court didn't go any deeper as far as the placement of the language, where it was located, the font, the size, any of the factors that were considered in the Creekside case. The idea that the statute of limitations in this case reset completely is not supported by the case law that plaintiff cited in its brief. The Ingram case that they cited says that if the alleged unconditional promise to pay is made before the statute of limitations runs out, then it's basically an estoppel, and that the plaintiff still has to file suit within a reasonable time after becoming aware that the debtor will not pay the debt. Well, the same account notes that they're relying on show that a couple months later, Mr. Thomas definitively stated to the representative of plaintiff's law firm, he doesn't have any money and he's not going to pay the debt. So at that point, the statute of limitations had just been told for that period of time, and they still had to file suit within a reasonable period of time. But I think it was about 3 years later when they finally filed suit. So they still didn't meet the test that their own case law sets out. The problem with the...
Make sure I understand. So you're saying their position is that they got another 4 years, 6 years, whatever the statute was, from the time, assuming your client said, yeah, I'm going to pay the debt. And your position is no, it was simply told for whatever that period of time, and then they had a reasonable amount of time, the statute of limitation didn't start all anew and run anew.
That's correct, Your Honor.
Right.
The case law that they cited about revival of the statute of limitations was when the statute of limitations had already run out, and that wasn't the case here. So it was just told for that. I think it was a month and a half or 2 month period of time. It was just told then. So okay. I'm out of time. We'd ask that the court reverse the trial court's judgment. Thank you.
Court's thanks to both sides. We appreciate your oral arguments and your brief here today. You would recess court until 1:30 this afternoon.
All rise.